Good evening, everybody. Thanks for joining us again. After 1 week off, we're back for another edition of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, along with my co-host who did make it out of the 4th of July, Julio Vela.
Hey, man.
No JPP July 4th for you, huh?
No.
Came back with all 10 digits.
Yeah, all 10, well, 9. No, voting acts. No, I'm just kidding. I have all 10
Good job,
digits.
man. Good job. I'm glad to see you followed safety first.
Hey, look, speaking of safety, anytime I'm with the most powerful defender in the most wretched war justice kind of area of the country, I feel strong. And so I'm very happy to be here today.
We have Alex Bunin, the Harris County Public Defender, here with us tonight, and two of his assistants, T.I. Vabell. Thank you for joining us, as well as Wade Bainum. Wade, glad to finally get you on the program.
Yeah.
I've been begging you for months, and you finally agreed last night.
I know. I finally broke.
I had to grovel enough. But we got a great show tonight, ladies and gentlemen. We're going to open up the phone lines halfway through the program. You can call in. 713-807-1794 is the number. We also have Twitter up. Hit us up there at HCCLA_TV. Julio, are you ready? Are you ready for open carry of swords?
Ready. I've been practicing my samurais.
Have you?
I've been practicing. You know, it goes back to a case I had like 2 years ago. This guy was leaving the flea market and was walking down the street with a sword that he had just bought, because he was going to go and hang it on his wall and these kind of things. He gets arrested for sword, unlawful,
Unlawful carrying a weapon.
Yeah, it was a prohibited weapon.
Yeah.
And the case ended up working out because he picked up some other felony. But another event, we were going to trial on that one.
Yeah.
Because if you can't carry a sword, what can you do?
I mean, I think it is very, very apropos that the open carry of swords is passed, or is put forth to pass leading up to the premiere of Game of Thrones. I just think it's great. I think it's perfect. But anyway,
amazing.
We're not here to talk about open carry of swords. I just thought it was a nice little way to start this show, ladies and gentlemen. But please get into our program tonight and ask us your questions and comments. But I want to start with asking you guys, since we have the three of y'all here, this is the month. This is the month it all begins for the changes that are coming to the bail system in Harris County, and you guys are an integral part of it. And Wade specifically, you're going to be on the front lines. So first off, I want to ask you guys, it was supposed to go into effect July 1st. It's now July 13th. The date's been pushed back a little bit. We're scheduled to start now at the end of the month. Talk about what's going to happen and why the delay.
Well, I really don't think of it as a delay. We were going to go forward actually July 3rd, which is a Monday. And I'd picked that date, and it was going to be a firm date, and it wasn't going to be when the new public safety assessment started, but because I was not sure that they were going to start on time or anywhere near on time, I just said, well, we're just going to start on this date. And then it became clear that they were going to start at least in July. And the judges asked me if I would put the date off. They needed some more time. In fact, today is the day that they've, at least the county court judges, incorporated in their local rules the new orders that will allow us to be appointed and unappointed after these hearings are over. So that took...
How does that work?
Well, there's going to be a standing order, basically, or a local rule that says any defendant who consents to our representation at that initial bail hearing will have a public defender representing them. That representation ends at the end of that hearing. Otherwise, we'd be representing every person in Harris County who's charged with a crime and have to be in court with them the next day. So we're going to be representing them for the bail hearing. The system will continue, as it always has, for courts to appoint from their roster of lawyers or from the wheel that next day if they're in custody or whenever they first appear in court.
So essentially there's no determination at the initial hearing of whether someone is indigent. It's if you want the PD's office to represent you at your bail hearing, you, the defendant, can consent to that? Well, it's only good for that hearing?
Actually, what will happen at the initial appearance, the new public safety assessment does not require a lot of work from the pretrial officers. A lot of the information in the risk assessment is data-based. But one of the things they will be doing now is a real financial affidavit, which had not been done before. So defendants will be swearing, these are my assets, and that financial affidavit will not only go to their ability to afford bail, but also to whether or not they should be appointed counsel. So that form will follow them to the court and be used. As you know, under our current system, basically what happens is if you're in custody and you get to court, they say, oh, you need a lawyer, and we'll appoint you a lawyer. If you get out, they say, well, maybe you don't need a lawyer. So hopefully we're really getting to a system now where they'll actually assess someone's ability to pay and not send them out to visit 3 lawyers or whatever system each court uses to decide indigence.
Right. Now, Wade, you were, I first came to know you over on the federal side of things when you were with the PD's office over there. You were there for a long period of time here in Houston. You were in Laredo before that, and then recently did a stint up in Wyoming before coming back here and taking this job. You've been here for 3 weeks. What have you been doing in order to prepare for this next role in your life?
I think, I mean, for the most part, I've been reading up on the bail statute and how it's been applied in other, not the bail statute, but the new PSA and how that's applied in other jurisdictions, because this has been tried in 20 cities and states, and reading up on that.
What do you think is going to be the biggest challenge for you coming in when this thing finally launches at the end of July?
I think there will probably be a lot of people that are going to be entrenched in the older system and just sort of gradually bringing about change. I think that will be the biggest challenge.
It's pretty amazing that you are a well-seasoned defense lawyer, defender, and you've taken a big shift, a big change to come over to Harris County. And obviously it shows that you have full faith and credit in Alex Bunin and his office and his team. But I have to ask, because you're not the only well-seasoned court warrior that's come down and kind of taken a shift in your duties and your aspirations and where you're going. And I'm wondering, you're going to be fighting PC all day, versus, I mean, I'd imagine a couple months back you were fighting, big public defender cases where the individual can't hire a lawyer or is indigent, and it's big drugs, big money, big fraud, big crimes, and you're going to go from there to fighting PC. We know down here that is the stage of how a case develops here in Harris County and the importance of that. But how are you feeling about that, and what drove you to make that change?
I think the exciting thing about this is that we're really getting in on the ground floor of something that it will be entirely new in Harris County. And, coming from the federal side, we did actually have detention hearings and preliminary hearings at times. And so we are sort of well versed in conducting those types of hearings. This is going to be exciting because it's going to be a big change. And it's a change that's happening not just in Harris County, but in other parts of the country as well.
Tiavi, you're mostly in the courts all day handling trials and everything else. How do you think this new program is going to impact what you do every day on your cases, the cases that come to you, how the appointment system works up at the court level?
I think that the new system will allow all of us to do our jobs a lot more effectively. A lot of times your clients make decisions not based upon what the facts are, but what they have resources for. So if I need to get out or else my family is going to lose my house, yeah, I want to fight my case, but I'm looking out for my family, so I might take a reduction or something else that allows me to get out. We have a system in place that they can go to court and be offered deferred, but the same court won't let them out on bond. If you tell me I'm okay to have a deferred, I should be able to make bond. I'm super excited about the people that are starting in the PC court, primarily because this is something new. And unlike a lot of people that will just be knowing this for the first time, we have Wade and Genesis who are masters at this. Yeah. So from the defense aspect, they get to help mold and create a system that they already know the pitfalls for and make sure that it works smoothly for the defendant. Whereas he can fight a drug case and his reputation. He can fight, they can walk, they go home. But how many other people is he going to be able to save before they even make it to court, because he knows the system and he knows what to argue And he knows that if I save them now, they won't take a plea when they get to court because they need to go home. It gives us all the ability to really stand up and fight for our clients, and it takes them out of the position where they have to make a decision to go home, and instead they can make a decision because that's best and that's what the facts require. And I'm excited. I'm excited about it all, and I'm excited about our team.
You mentioned earlier that the I guess the public defender's office will be appointed and then removed after that particular stage in the proceedings.
Right.
So I guess there is a possibility that the public defender's office would be reappointed to that individual later on?
Absolutely, yes. So we're still in the same system, and information we collect, we will have conversations with defendants at those hearings, mostly to gather information to show the magistrate why they are not a risk for flight or a danger to the community and should be given personal bonds, should be given lower cash bonds. But the information we gather, we would pass on to either our lawyers who are representing them or other lawyers, so all that will be available. One thing we haven't talked about, and maybe you've talked about this on another show, is that we're under a federal court order right now. So part of this, these changes, these reforms, the public safety assessment, lawyers' initial appearance, these are all good things. Judge Lee Rosenthal, who is the federal district judge that put Harris County under this preliminary injunction, has said these are commendable things. But she also recently said, these don't solve everything that I asked Harris County to do. This needs to be a cultural change. Even if we fight for defendants, even if there's this risk assessment that we can use that says this person should get out, there still has to be actual effect from this and people getting released.
Yeah, and I was going to ask you, Wade, I mean, talking about the cultural change, I mean, the difference for you coming from the federal system to this is there in preliminary hearings and bond hearings, it's a question of detention, no detention. It's not really a question of, I mean, there's a little bit of arguing about bond and the amount, but really there the ultimate question is the government moving to detain somebody or are they actually going to get a bond? Here, I mean, you're arguing over whether somebody is going to get a monetary bond and what that amount is versus somebody who gets a PR bond. What do you see as being the issues that you're going to be dealing with? I mean, are there going to be witnesses present for this? What do you see as the structure of these hearings going to be?
I think this is probably, given the numbers that we're going to face, probably going to have to be more of a proffer, where we proffer the client's situation to the judge. I don't anticipate us being able to have time to call witnesses with the numbers that we'll have in the state. I think, in addition to getting them out on bond, we're also going to have to make sure that they don't over-condition people. Make them get on a monitor and pay X amount of dollars per month when they can't afford it. So, that's going to be another challenge that we're going to have to face.
Is the state going to have somebody present at these hearings as well?
The state has always had someone present at these hearings. The way it works right now, and it will probably for the next 8 months until we have a new inmate processing center, is that we'll be with the defendants over at
physically
at the inmate processing center, physically over there on this side of the video. What you see at the courthouse is there's a magistrate and an assistant district attorney, usually a division chief, sitting in a kind of small courtroom, and they're watching the monitor and they're talking to whoever the defendant is. This new system, it'll be the defendant, but it'll also be one of our lawyers speaking for them, which will solve one of the biggest problems I've always had with the system is people make incriminating statements at these hearings. And I brought this up to the judges before, and some of them said, oh, that's not a big deal. And
it's on video.
I know.
It's kind of
I remember at one of the judges' meetings, to his credit, Ryan Patrick, maybe soon to be our new U.S. attorney, said, oh no, I used to write that down all the time. So it is really important, and if we do nothing else, we'll be protecting their rights at that hearing. But I know we'll also be doing a lot of good advocacy too. One
of the things that I'd like to touch on is the numbers. Are you all just going to be involved in misdemeanors and felonies?
Everything.
Everything. Wow.
And you talked about a cultural shift, Alex. I mean, we've seen the videos of these magistrate judges berating people, just talking down to them. I mean, that seems to be one of the real big fundamental shifts that needs to occur, is just from that level, how these guys fundamentally treat human beings.
Right, but you know, to defend, take the devil's advocate, defend them slightly, it can be very frustrating.
Sure.
In these situations. And one of the things we'll be taking away is some of that frustration in that they'll be discussing this with a lawyer and not someone who's obviously very upset because they've been arrested and are facing charges and don't understand what's going on. So that will improve greatly. I think the biggest cultural change, though, will be understanding that in Texas we have a very limited system of preventative detention. For misdemeanors, there's basically nothing for a new charge. If you've got been on a protective order or on a bond for a family violence case, there's provisions to hold you if you get a new case. But otherwise, you really can't detain people for misdemeanors in Texas. And what we've had is kind of a system of preventative detention by money. So we just set bonds that are high enough that people can't make it. And that's really where we need to be advocates and show the magistrates you can't keep people in because they can't pay.
Right. How is that going to work with the protective orders and stuff? I mean, are they going to shift that? Because a lot of times the county court judges or the district court judges are the ones who want to do that. And so a person will sit in custody. Is there going to be a shift to try and do that now at these preliminary hearings versus waiting until they get before a county court judge or a district court judge?
You know, I don't think that part's going to change.
Okay.
I don't think so. In fact, the magistrates are going to have more to do now, and they're going to have like 2 per shift, because a lot of these cases, because the risk assessment is going to identify them as paper ready for a personal bond, one of the magistrates will be taking cases directly from pretrial officers and signing off on release orders. And then the other ones will be dealing with the hearing and dealing with our lawyers. So it will extend their work quite a bit.
Are we potentially going to see PR bonds for felonies too?
That, you know, I've seen the new bail schedules, and the ones for felonies do have presumptive personal bonds for instance, state jail felonies. So if you come up and you're a lower than average risk and you're faced with a state jail felony, in most cases, that's a presumptive personal bond. Again, it's the culture, though. The risk assessment may say that, but we need to have it applied, and the lawyers will help get it applied.
How much do you think your trial docket's going to explode, as some people will say, Tiava?
I don't anticipate it will explode. I actually see it going the other way. It'll force prosecutors, because now you get a little bit more information. They're able to provide me, let me explain it better. When your client is out on bond, they can give you resources that take more time for you to get them on your own. Instead of me sending an investigator out to talk to your mom and your cousin and get affidavits from those people, you're going to go home and you can bring them to the first meeting. That allows me to put together a grand jury packet or put together enough information to actually have a conversation with the prosecutor, and we can get on the same page a little earlier in the process. Nobody wants to set bad cases for trial. The state doesn't, the defense doesn't, and if we're in a position where we can use information to get to the same point, allow us to get there quicker. As far as, you know, my trial docket exploding, if it was a trial case, it was going to be tried anyway. And if it's one that needs to work out, we just get to the resolution faster because we have more information and we're not bogged down by them being in custody and jumping through all those hoops to get to that point. If you have a sex offender and they need to be evaluated, do you know how difficult it is to get that evaluation done in the jail? That in and of itself will make that case lag on for so much longer. But if you can send them over to the doctor and get it done quickly, it allows you to determine what they qualify for and what they don't and rule out those options a little faster. It speeds up the process on the defense side because it kind of takes the handcuffs off while you're doing your job.
Yeah. One final thing I want to get you guys' thoughts on before we kind of switch topics here a little bit, but a lot has been made from the far right that this is the last bastion of entitlements. And having the 3 of y'all here from the Public Defender's Office, I think this is a good question to ask you guys. The argument has been posed that there are no more entitlements left in government system. So now you're going to give them free bonds. The next thing is everybody's going to get a free lawyer. What's y'all's response to that?
Well, they're not free bonds. First of all, there is absolutely.
Well, that's the way the bond's been counted.
Well, okay.
Free bond.
Well, I understand, but they have a business to run, and it's in their interest to say that. But there really is no more incentive to show up to court just because you've given a bondsman a non-refundable fee. Once you've done that, that does not increase your chances to show up. You're not going to lose anything if the bond is forfeited. I mean, rarely, even if you put up even if you have a personal bond where you've signed and said, I will pay this amount if I don't show up, the county doesn't go after it. So there's really no difference. There's no what people have called skin in the game for that system. The way the system works is if you over-condition people, if you put people in jail when they're not supposed to be, you increase recidivism. You do all the things that conservatives should be against, and it costs more money. So the smart on crime people, people like the Koch Foundation, the Koch Brothers Foundation, and a number of groups in Texas support this kind of thing because it saves money and it's smart on crime.
Yep. You were going to say something?
And also keeping somebody in jail is like the purest form of welfare. I mean, you're taking care of their needs, their medical needs, their food. I think that's why it's become a bipartisan issue because both sides realize this is an enormous cost, not just in terms of the humanity of it, but in terms of taxpayer money.
Yeah.
I mean, we have something around 646,000 people in jail, of which 70% are pre-trial, meaning they haven't been found guilty of a crime.
Yeah.
And taxpayers have to pay to take care of that.
Yeah. So.
For people that, like Tiaiva said, will end up getting a deferred, or if they have a misdemeanor, they'll get time served.
Or part of this new pretrial diversion, these diversion programs that we're looking at and expanding. So
Right.
What I have seen is my bond docket is, because I take a lot of misdemeanor appointments, everyone's on bond. The only people in custody are people with some serious problems, some serious other felonies going on, or ICE holds. Mm-hmm. So I go back to the holdovers, and there's 5 people back there. 6 people. And those guys can't get, because they got an ICE hold, they're not getting out. They got some way more serious stuff than this trespass that we're dealing with here. Or there's something else that I've actually seen almost every day, at least one person back there who hasn't been interviewed by pretrial yet. And so it's a trespass, it's a driving while license invalid, it's mischief, it's something that they should get a PR bond, but they're not. They haven't gotten it yet. That's still happening. I don't know why. And then when you go and talk to the judge about it, they're like, they relish the opportunity to say, oh, no, we're not going to call pretrial on this. I'm actually going to raise this bond to $1,500 or to $2,000 because this is bad stuff. And so you're seeing that happen to these people. But my bond docket is going insane now. But we've talked about, well, now everybody on bond's going to want to go to trial. But what I've seen now is more individuals and more offers being made for alternative recommendations, class and dismiss, what they should have been all along.
Absolutely.
Take a course, we'll dismiss this case, we'll offer this deferred, versus the bring them in, plead them, and let them out. And so we're already starting to see some changes, which is good.
yeah, we'll see. I'm looking forward to seeing how this all plays out, and hopefully it's not the giant train wreck that some people have thought it will be. I want to talk about this interesting story that I came across, and it deals with an opinion coming out of the Court of Criminal Appeals on delivered at the end of last month about a writ dealing with ineffective assistance of counsel. And the issue, it's not so much interesting about what happened in the case in terms of the ultimate decision of the court, but this is something that we've known about in Harris County for a long time now. And it deals with whether or not their police are incentivized to make bogus arrests for their overtime pay. And it was interesting the way they outlined the facts in this opinion. Ultimately, they reversed the the ruling of the Court of Appeals, but that's neither here nor there. The issue is whether or not an attorney was ineffective for not getting the overtime records and being able to cross-examine a Houston police officer. For those who don't remember or are unfamiliar, there was this notorious DWI task force officer about 10, 15 years ago, going back a little further than that, Officer Lindsay, who literally made more in overtime than he did in salary. I think he made something like $65,000 in his actual salary, but then made $85,000 in overtime, the bulk of which was testifying for DWIs in court. The Court of Appeals originally found that the lawyer was ineffective. The Court of Criminal Appeals reversed that finding. But it is the real question at issue here for me is, and it doesn't seem like the overtime issues have really changed. And I really never got into this whole thing. I knew about it. I kind of had some cases that dealt with it. But how officers get paid that they can show up for basically 50 minutes of time during an 8 to 5 period and then get paid for 4 hours of overtime in certain situations, that really struck me as absurd. It really did. I mean, how are they not incentivized by that?
Yeah, and I think it's probably a particular issue with the DWI task force officers because there are a limited number of them. They're constantly in need, and they are constantly needed to testify. So I think that's probably a big issue with them, and you probably do need to do investigation if you're going to cross-examine them. I don't know if it's ineffective in every case to not have done that, but I understand that issue.
Well, and most of these cases are misdemeanors. So what is your office's policy in terms of getting those records? What are the types of things that you guys have to go through in order to get those types of things? And is it even an issue?
It's not much of an issue in our office because the only misdemeanor cases we handle are severely mentally ill defendants.
Okay.
And they typically are not driving cases.
Well,
now, we might have an involuntary manslaughter case where it could come up, but it's not a regular issue because we don't do the kind of volume DWI work a lot of folks do. So,
gotcha.
But it would certainly be fair game, yes. That would be something you'd want to investigate. If it's one of those task force officers and they're going to be cross-examined, yes, you'd want to know that.
Especially when this officer has a reputation of pulling people over, arresting them on something less than probable cause, kind of puffing on their affidavits, knowing that this person's going to go to trial because they probably shouldn't have been arrested anyway and they're probably not intoxicated. So this person's probably going to go to trial because a lot of the DAs in the misdemeanor courts, they're looking for convictions or don't know how to evaluate a case, or sometimes they're just overworked and can't screen the case as well as they should. So then they go to trial and then they get an acquittal, and all this whole time this officer is billing and making mad money on it. I think that's a problem, and the way the system is set up for the overtime pay is an issue. Imagine if the public defender's office or anyone went to, let's say, the commissioner's court or whoever's approving these overtime schedules and say, yeah, we're going to bill you for 4 hours of work, but we only were there for 55 minutes.
I mean, Tiavi, you were on the other side. You handled these cases.
I did.
How much did this come up, and how would you deal with it from a prosecutor's side of things?
See, I've always hated DWI. I don't like those cases. I don't like trying them. There's a lot of math. I didn't.
You don't like math?
No, I'm here.
Especially
I don't do
fuzzy math.
I don't do math. As far as the officers and their overtime, I didn't really have some of those issues, and I think that there's some things the prosecutor can do in order to help combat that, but you also have to have something in place that serves as a check within their own organization. I think I was reading that HPD had a problem with their overtime, and they started an investigation based upon some of these things. As a prosecutor, you know if your case isn't going. Let's be honest, you know that you have 6 on the docket, and there's probably 1 that'll go. Instead of having the officer show up, do what a lot of prosecutors do and put them on call. Say, just call me, I'll call you if you need to get here. We should make sure that we take efforts to do things like that, even if your case is in trial. How long will it take you to be here? Don't come down here and waste the county's money or time to just sit here. I'll call you when we need you about 30 minutes out. That allows you to maximize their street time if it happens to be a day shift officer, but it also reduces the amount of time that they're allowed to do this. If their department won't take the steps in order to combat this, as a prosecutor, you want to make sure your convictions are righteous, so don't let them use you. Put them on call and call them when you need them, and sign the timesheet for the correct hours right away, because an officer can come up, oh, I've been here since this time this morning. I'm sorry, you knew court didn't start at 7. It started at 9, and I told you we're picking a jury to 10, and we're not doing that today. We have to employ common sense approaches. If they won't be a gatekeeper at HPD, I think the prosecutors should step up and do their part in order to make sure that they're getting officers who are trying to do the right thing and doing it diligently.
You know, Chief Azevedo, as we were coming into the show, was doing an interview on 88.7 on NPR, and he was saying that Houston's still understaffed. Officers are overworked, and their budgets are to the max. And so, the idea that these types of incentives are still going out there, I think there has to be something institutional with HPD that has to change, or on their overtime pay, to prevent these kind of things. But even now, with the things that he's trying to change and the things that he's bringing in and the new ideas and programs, you can't fix a system that's broke and stretched to the max. And so I don't know what the fix would be.
Well, but one of the big questions and in this whole story was, if they are testifying between the hours of 9 and 5 or 8 and 5, and that's their regular shift anyway, why are they getting paid overtime for it? Why are they getting paid overtime?
Is that what it says? Because normally,
yes.
I mean, when I was a cop, you only got paid for overtime if it was outside of your shift.
No, in this case, they cited a specific example where the officer clocked in for court while he was still on regular time, and it extended over by like 50 minutes, and he got 4 hours of overtime for going 50 minutes over his normal scheduled time that he was already on duty. I mean, if you know that kind of math, and we all hate doing math at this table, but it doesn't take a rocket science to figure if I can go sit somewhere for 50 minutes and get paid for 4 times the amount of time that I'm there, I'm signing up for that gig every day. And I'm going to figure out a way to do it.
I think that is probably like an extreme situation. You also have the situation of somebody who works the night shift who has to come to court during the daytime, and it's not just the time that they are actually in court, but they have to get dressed to go to court, travel to court, sit there and wait for a while. I think that's probably more common.
You mean where they're coming off working from a 10 to 6 or something like that?
Yeah, they were working in 11 to 7, and then they're having to go to court, at 1 in the afternoon.
Sure. And that's understandable.
Right.
I mean, that would be overtime, where you're not working within your confined hours and going testify within your confined hours. But they were able to point to instances where guys were coming to testify during their normal shift and getting paid overtime for it.
Yeah, I definitely agree that 4 hours is way in excess of what they should be doing.
I mean, when you were a cop, Wade, how much overtime did you get for? I mean, was it hour for hour? I mean,
No, every time you went to court, it was 2 hours.
Really?
Yeah, if it was outside of your shift.
And
if it was within your shift, you got nothing.
Okay. And you were up in Kansas?
Yes.
Okay.
Yeah, well, that makes sense, right? That makes sense.
Yeah.
So you would get time and a half for overtime, basically.
Right, correct.
Not time and times 4.
I mean, does it make a difference though? I mean, is it relevant? Does it make a difference?
I don't know, but
how would you use that information at trial? I mean, what would you do?
If the officer was making a lot of overtime.
Yeah, I mean, he's keeping people off the streets that he think might be drugged.
Well, but I think the issue here in these cases were...
I'm playing devil's advocate here. Okay.
We're here in Houston, the issue was, and this is the theory that the DWI task force was setting up in high-income areas, pulling over people in higher value cars that may or may not have been intoxicated, but they knew that those people would have money, hire lawyers who would force the case to trial, and ultimately that they would get overtime pay because those cases were more likely to go to trial than somebody in, a beat-up old Grand Marquis from 1975. I mean, that's the reality, and that's
not anymore now because they're on bond, right? See, that's what I'm saying.
Right.
We're going to see these things happen.
But that was the theory of this whole overtime, that it incentivized these officers to go into these areas, arrest higher dollar people for, higher income people that maybe they are, maybe they're not. But this was also back in the day before we had mandatory blood draws too. So it was no test, no accident in a lot of cases. And those almost inevitably went to trial all the time. It was a different time back then.
NTNANG.
Now not so much. We have reached the halfway point of the program, ladies and gentlemen. We're going to open up the phone line. 713-807-1794 is the number. We also still have Twitter up. It's pretty silent out here, although one person did comment.
Yeah?
On your, calling Wade, I think it was whale seasoned.
Right, a whale seasoned lawyer.
Seasoned.
That was a play on whales.
So if you pick up on any of Julio's idiosyncrasies and his pronunciation, please continue to call him out on it. We need these things. All right, guys. Federal bribery indictment this week, unsealed, here in Houston. This is interesting to me. And there's a lot of issues I want to discuss about this because we are now seeing, there was a lull for a long time in public corruption cases here in Houston. Now, if you're going to tell me that public corruption has been on a lull for 15, 20 years, I probably beg to differ with you. But we've seen a couple here now this year. This one is interesting to me. There was a HCC trustee who the indictment was unsealed. He was charged back in March. Comes out that he extorted another person to pay him a bribe. And this is just an interesting fact scenario because also you look at the plea agreement in this case, and the government agreed to dismiss the extortion part of the indictment as part of the plea agreement. Okay? Interesting. That your theory is he extorted him, but then you're going to dismiss that portion of it. All right. How does this guy not know that he's going to get what he's paying for? I mean, how is he really a victim? At a minimum, shouldn't he have reported it to the FBI? And isn't he at least guilty of knowing that a felony has been committed and not reporting it to the authorities?
That may well be true. But if you're the federal prosecutor and you need a good complainant, then that may be your better choice of the two as the person who is the victim for your case. You're gonna need somebody to cooperate.
But they need to deal with the trustee. Why did they need this guy to be the victim to be clean?
Well, if he was thought to be a valuable witness, then they will give him something valuable in exchange.
Perhaps immunity.
Perhaps.
Paid administrative leave.
Yes. Okay. So explain to me this. Riddle me this, guys. How does the trustee get a censure, and the guy who paid the bribe get a paid leave? Can anyone explain that one?
Now, without more information, no.
I mean, that's just bizarre to me. It is just bizarre. And here's this guy who's been sitting under indictment for almost 4 months now, pled guilty, and he's been going to all the HCC meetings, sitting there with the board. You can't tell me he wasn't wearing a wire.
You think?
You cannot tell me he wasn't wearing a wire the entire time.
That's
right, Wade?
Awesome.
I think somebody got to the table first.
You think?
Yeah.
What is the old saying? He who gets in first gets the best deal?
Exactly. Yep.
I mean, this is the classic case of that.
It's the same thing if you're being chased by a bear. You don't have to be, you and a friend are being chased by a bear. You don't have to beat the bear. You just have to beat your friend.
Yeah, you just had to outrun him. I mean, that is clearly what this guy. This guy clearly outran the other guy.
He outran
on
everyone. I mean, paid administrative leave. This is what happens.
Yeah.
But I agree with him. They did have to have somebody probably testify and cooperate.
And so and so that's why you keep the victim clean.
Mm-hmm.
Well, yeah, and you know, there's a lot of different choices they make in these kind of cases. So
Right.
you don't know all of what they had and all of what went into that, and what their priorities were. You were saying there weren't a lot of corruption cases, and now there's a corruption case. You know, political
Tides are changing.
change. You know, I've been a federal public defender in many different districts, and everywhere I went, it was a little bit different what the priorities were.
Right.
If you had a border patrol office, then you had immigration cases. If you didn't, then you didn't have them. It didn't mean there weren't people that could be charged with illegal entry. It just meant that wasn't a priority because there was nobody to make those cases. If you had an IRS office, you had more tax cases. I remember when I was a federal public defender in Beaumont, and if you're driving a load of dope on I-10 out of Houston, if you got stopped in Chambers County,
Oh yeah.
you might pay a big fine and get probation. If you cross that line into Jefferson County, you're in Eastern District, you might be going to federal prison with a mandatory minimum. So there's nothing uniform about federal or what priorities there are, you know, and who the U.S. attorney is. That all makes a difference.
Yeah. I'm really interested to see as this case unfolds. I mean, it's just interesting to me the where this thing can go. And for a long time, we've talked about amongst the defense bar, every now and then something will creep up. I mean, you had the Eversole case a couple years ago. Now this creeps up. And every time one comes, there's just always this thought like, how can there not be more? How can there not be more going on? And you know, I read an interesting article the other day about the lack of prosecution of the Wall Street executives.
Yeah, I read that.
Following the collapse in 2008. And one of the things it said was that what's going on, at least their theory was that you have these Ivy League elite law students who then get jobs at the DOJ. They all go to school and go to prep school with the bankers, the Wall Street guys, kids, and then you have kind of this inflow and outflow from DOJ to private practice, and it becomes a real wish-wash that nobody really wants to ruffle any feathers. Nobody really wants to be the one to say, we're going to lay down the hammer here.
Right.
And I wonder if some of that hasn't gone on here with regard to public corruption.
Well, there's that, and there's also that those cases are a lot of work. They take a lot of investigation and effort and time, and it's a lot easier to make things like drug cases, you know, that are you can have do a buy and you can bring somebody in and
Or illegal
it looks
reentry.
great. Yeah, or legal, yeah, and say you're protecting the borders.
Bring the immigration file in. He was deported back.
Yeah.
Back. I mean, that's really kind of a no-brainer. I mean, to make these cases, you have to get a guy like one of these two guys to be your informant. You have to work them. And it takes, I mean, no telling how many years this has taken to get to this point. But I also, you know, wonder how much of it is that versus how much of it is, you know, similar to what went on with why nobody was prosecuted on Wall Street, and that nobody wants to be the one to really drop that hammer.
Right.
And I don't know. I kind of feel like there may have historically been some of that here in Harris County.
You'd like to think that when everybody's sitting in these high places and someone says, hey, why don't you do a job for me? Like, you gotta be smarter than that. Hey, why don't you do a job, we'll pay you. Why don't you go clean up my, what do you have, a strip mall or something? Or why don't you do some services for me and we'll hire you to do that. No, I know other people are vying for that contract, but don't worry about it, we'll give it to you.
I think a few years back there was a U.S. attorney in San Diego that was removed because they wanted to start doing white-collar cases in San Diego, but D.C. didn't want them focusing on that area. They wanted them to focus on border areas. Yeah.
Well, and I mean, you know, you guys, in what you do every day, you represent people who have no money, and they get railroaded by the system all day long. And quite often, I mean, whether they are righteously prosecuted for an actual offense or not. To me, the biggest injustice of it all, what you were talking about earlier, Tiaiva, is just this: the punishments don't fit the crime, and they never have. They never have in this system. And it's one thing to say, you know, all right, you got caught with marijuana, or you got caught with this, that, or the other, or whatever. But for the people who don't have money and don't have the ability to fight, I feel like the biggest injustice here is the fact that they are not punished the same as everybody else.
Right. Yeah, they're overpunished, and they don't have a voice, and the people that make these priorities get a great benefit from this. I noticed you put on your list of things to talk to our new Attorney General on the war on drugs.
I'm going to get to that next.
Well, I'm going to beat you to it, because when I became the federal public defender in Southern Alabama, Jeff Sessions was the outgoing U.S. Attorney. So not only did I know him, and he lived 4 blocks from me, but I knew all the people that he appointed, and I knew the history of how he grew that office on the war on drugs. And so he basically built his career on that. So he gets 2 benefits. One, he gets a big name for prosecuting people. He gets to grow that office, become more powerful. It was a stepping stone for him to be Attorney General, then Senator, now Attorney General. But also he got to disenfranchise a lot of people that probably would have voted against him.
Yeah.
It's amazing.
We got a phone call I want to get in here, and we're going to touch more on Sessions and his new war on drugs. But let's get the phone call in here. Hi, thanks for calling Reasonable Doubt.
Hi, I'd like to ask the panel. JB said that there was a lot of improvement in the holding cells, and people are out on bond and that kind of thing. Is there a risk of things? Can you hear me? I think I'm breaking up.
No, we can hear you.
Okay. If there can be maybe Alex can speak to this. If there's a risk of things returning to the old way, but because it's been so ingrained for so many decades that people, as you say, Jimmy, people have been treated so unfairly. If they think that that there's just so much inertia in the system that it'll just keep going the way it'll turn back to the way it was, and especially with the county commissioners fighting all of tooth and nail to keep the old system in effect. Can you speak to that?
Sure, thanks. Great question. Yeah, I mean, I've likened it, Alex, to we're trying to turn the Titanic on a dime to miss the iceberg.
Right.
We're a county of 4 million people, and now we're trying to do a big switch overnight and reverse decades of...
I have to say there's a lot of cognitive dissonance when you talk to judges about changing it, because they basically grew up with this. Most of the judges are my contemporaries. I went to law school with a lot of them, and I remember the system, and it's always been, at least certainly in the county courts, a system where people stayed in custody and they pled guilty to get out. And that is unusual throughout the country. We incarcerate a lot of misdemeanor defendants, and that's what Judge Rosenthal found. It was like 40% we incarcerate, and they get out by pleading guilty. And we don't notice it because they don't stay in that long, because they'll get time served. Mm-hmm. But now they've got convictions, and now they're stuck in the system, and next time it's worse. So changing that system creates a lot of, again, cognitive dissonance, denial, and it's going to take time, and there'll be changes. There'll be different judges. People will come to learn that we can be different. So I think I'm optimistic. I think things will get better. I think culturally the reforms we're putting in place will do that, but we have to fight hard.
Yeah.
We can't give up.
For sure.
You all are going in at the ground level. It's a tidal wave coming, and I have to just say I'm so impressed and amazed that what y'all's office is doing, the people on the ground level, that you guys are literally at the footsteps of history. You have the changes in one of the largest counties in the country, the epitome of what the system should not be like, and you guys are going in there to fight and change. And quite frankly, I don't know how y'all are going to do it, but I know you guys will, because I still believe that at the end, with good people, justice prevails, and I'm looking forward to it.
Well, and as Alex gave me the good lead-in, I mean, our Attorney General is trying to take us back, back in time to the good old days of
Dare.
hardcore justice and dare and everything
And he
else.
does it. It's not even really that popular anymore. I mean, it's really served him well in his career, but it's no longer the conservative mantra to lock everybody up.
And I find it funny because I sent this out to you guys last night, to, the topics we're going to talk about. And he gave a speech in Dallas earlier this week where he talked to, about reviving the DARE program and how well it worked. Okay.
No comment.
Yeah. Apparently he was in a different room than me.
Facts.
Yeah, exactly. And then today we get the announcement of 4, and it's all been about opioids. Okay, that's his new war. It's all about opioids and reducing our opioid addiction. And the interesting thing I found is they had 412 arrests today, 412 indictments unsealed. They're healthcare fraud indictments. Let's call it what it is. And they want to say it's a war on opioids, and they're using the Healthcare Fraud Task Force, which has been historically over the last 5 years and a little bit longer going after, false Medicare, Medicaid billings, and they're now using it as a new tactic in the war on drugs to go after these pain management clinics. I found it stunning what he's trying to shift this thing to do.
Yeah, well, he has to make sure the people he's going after aren't going to be the kind of folks that are going to come after him later. So, I mean, the opioid epidemic has hit the populations that voted for our president. I mean, in the Rust Belt, places, all those have been savaged by it. So for him politically to take on and start putting those users and small dealers in prison is not going to do well for him. So he needs a different enemy, and I guess that's it.
And that's what I'm interested in for get y'all's thoughts is, how do you think this filters down to the state level? I mean, are we going to see a return of prosecuting some of these lower level script fraud, addict fraud cases?
I think Sessions is out of touch. I think that a lot of, state level people will not agree with his approach.
Hope so. I mean, and I think in a county like this,
Yeah, I don't think our district attorney is.
But I can see others doing it. We got another phone call. I want to jump in here real quick. Hello, thanks for calling Reasonable Doubt.
Hi, thank you for taking my call. Since your guests are all with the Public Defender's Office in Harris County tonight, I had a question for the way that it works in Harris County for indigent clients. How do they decide if the Public Defender's Office is going to represent somebody, and how many cases do they take in our community, and is there a way that you could ask for the Public Defender's Office to represent you if you're indigent? And lastly, do they think their office will expand like some other communities where the Public Defender's Office represents all indigent people? And I'll take the answer off air. Thank you.
Great, thanks for the call.
All right, I'll try to answer that. So we don't choose our clients. There are different ways we get our clients. In the misdemeanor courts, there's actually a computer algorithm that finds who the most seriously mentally ill defendants are, and we're assigned those cases. And we know the same time the court knows who our clients are going to be that morning. In the felony courts, we call it the wheel. It's a computerized system that spits out 10 or so different lawyers that are approved. We're on that wheel. We can take ourselves off the wheel. And those different felony courts will call us. Their court coordinators will say, we have a case for you. Some courts call us all the time. Some courts call us less of the time. A few of them have their own contract system, so they rarely call us unless there's a conflict or some other kind of problem. We get cases from the juvenile courts, and we also get appeals, but they're all assigned by the courts. So people can't come to us off the street and say that. I don't know that it would help a defendant in court to say, I want the public defender. Some judges would find that not helpful and choose someone else.
How many people show up on at your office on the 13th floor and ring the bell and ask for a meeting to try and get representation?
It happens, but not that often. Not that many folks are that proactive to do that. But
Should take them down the hall to wait to interview them for a little bit.
I tell you, it's very confusing because people don't know the difference between public defenders and private assigned counsel. And I'll get calls from a family member complaining about a lawyer. And through the conversation, I'll say, well, who is this? I said, well, they don't work here. That's not a public defender.
Yeah.
So there's a lot of misinformation about who we are. Most people are represented by private assigned counsel in Harris County. We have less than 10% of all appointed cases. We do have now, I think, 53 lawyers, a total staff of over 80, including investigators, social workers, administrators. We have now exhausted all our space on the 13th floor of the CJC, so we're trying to build offices within offices.
We've also exhausted the useful life of the elevators.
The elevators, right. So we will grow, but what I really want to do is make sure that the private assigned bar is well resourced and takes cases that they can handle and manage. We have some folks that take too many cases and don't have enough time in the day to do them. And we have folks that don't ask for resources from judges or don't get them. Cases should be investigated. They should be researched. You can't just do volume.
I mean, and the two of y'all came from the federal side. You have a lot of experience over there. I mean, the federal PD's office, they're the first choice, and it's only if there's a conflict that private counsel from the Criminal Justice Act is appointed. I mean, do you think we ever get to that point in Harris County?
We would have to be really huge, and I don't think that is necessarily the best way to do it. I think we don't want to diminish our quality in any way. So I want us to get as big as we can and still be good. What I really want to do is help. We have many good private lawyers that take court appointments in Harris County, and I want to help them do better rather than just us take over every case.
What's the ideal size for you? What would you like to see the office grow to?
I don't know. They have to show me where the space is first.
Ideally, you'd like to have space to put the
Yes.
lawyers. Man, we're almost out of time. This hour flew by.
That's great, man.
Can you believe that?
It's really good. I just listen most of the time. We got a great team here.
We do.
So awesome.
We do. It's been a good time, guys. I appreciate you coming on. Tiava Bell, Alex Bunin, Wade Bainum. I'm gonna get you to come back. You turned me down twice.
We'll see.
Yeah. Turned me down twice, but as any good aggressive host will do, they keep asking. Finally break down your will.
Yeah, you broke it down this time.
Anyway, ladies and gentlemen, this has been another great show. We appreciate you tuning in. Go check us out on Facebook and come and like us on Twitter. Follow us on Twitter. We've got a lot of great updates. We'll post clips of the show. We'll also post all of our upcoming shows, topics, guests, that sort of thing. You can follow along there. But that's all the time we have for tonight. For this crew and my co-host, Julio Vela, good night, ladies and gentlemen.